Hello everyone. Welcome to this lecture on this new section on forensic psychiatry. In this lecture, I'll be covering about how forensic psychiatry is dealt with, how the interviews are conducted, what are the basic requirements for a medical legal case, and some smaller topics relating to forensic psychiatry. So let's dive into it. First thing, why do we want to talk about forensic psychiatry? Why do we want to talk about psychiatrists in the courtroom? First, because most of us are very apprehensive about legal involvement in cases. There is anxiety associated with court ordered evaluation. If we receive a letter from the magistrate that they need some form of report about the mental status of an individual, then it is a worrying situation. There is lack of confidence in performing assessments for this purpose. There is also fear that the judge might call us for appearances during court as an expert and give our findings in the court. So that is another fear. There is also concern that the patients that one is assessing might be dangerous. They might be threatening to you. Patients can be threatening to us. They might be charged with murder, sexual abuse, and giving reports against them that might go against their case can put us in jeopardy also. So these are the major concerns one has as a psychiatrist when dealing with medical legal cases. Now, what are the kind of cases that we usually deal with? We can deal with cases such as family suicide, mass suicide, for example, the Burari deaths in Delhi. That can be one of the scenarios where a psychiatrist is appointed by the team to understand the psychology behind the committed suicides. Then it can also be when mentally ill patients commit some offense and the court asks us whether the patient has any mental illness or not. One can be called for homeless patients and homebound patients with no history of information. So for them, psychiatrists can be called regarding evaluation and management of those patients. Sometimes patients can be captive in certain situations. For example, a case of a 60-year-old female who had been suffering from schizophrenia, had locked herself up in her home for the past 2 years and would not let anyone enter into it. So for rescue of such patients, that may be psychiatrists may be called. Secondly, from rescue of people who have been victims of violence, abuse, disasters, for them psychiatrists may be called for evaluation, for example, in POXO cases, etc. Now, forensic psychiatry deals with the psychiatry law interface wherever law and psychiatry comes into being. So it might not just be criminal cases, it can also be regarding the Mental Health Care Act, regarding admissions, regarding reporting of child abuse, regarding narcotic drugs being seized. So in all those cases, forensic psychiatry comes into play. And this spectrum deals with not just criminal cases but civil cases, some correctional institutes, and other legal matters also. Psychiatrists are called for expert consultations to assess the risk. In some situations, psychiatrists are also asked whether a person is fit for duty or not, particularly in cases where armed duty is required, such as police, armed forces. The psychiatrist can be asked whether a patient with some mental illness is fit for carrying out duty and what kind of duty. So for them, psychiatric consultation can be taken. Besides that, forensic assessments are time oriented. This means that uh, one one can be asked to assess the past, the present, or the future of an individual. For example, if a crime has been committed, then the psychiatrist can be asked whether at the time of committing the crime the person was under influence of mental illness or not, was the person responsible for committing the crime or not. At present, the psychiatrist can be asked to give a report whether an individual is fit for trial, does he understand the court proceedings or not. Or they can be asked to assess the risk for future, risk for repeat offense, risk for using violent means in armed forces, fitness for duty. So that can be to predict future risk. So these are again a variety of subjects where forensic psychiatry comes into play. Now let's talk about what we are going to cover in this lecture. We are going to cover what the basics of forensic interview are, how it should be conducted, how it should be documented, what things you need to keep in mind when conducting a forensic interview. We'll talk about what capacity is and what competence is. We'll talk about fitness to stand trial, how it is assessed, how it's done. And insanity defense, we'll talk about how what are the legal provisions for insanity defense, and how it is again assessed. Now, starting with sources of referral, from where all can we get forensic psychiatry cases. First of all, we can get it from criminal courts for criminal responsibility. We can get from child welfare committee in cases of sexual abuse under POCSO Act. We can get it from juvenile justice board for crimes related to juveniles less than 18 years of age to assess their maturity and responsibility. Also, investigating officers can bring cases directly to us for some clarification regarding mental illness. Police can bring homebound or homeless cases as under the MHCA sections. Civil courts can sometimes ask for competency evaluation. These are the cases where competence to for marriage, competence for divorce, competence for child custody, competence to make will. So these kinds of evaluation can also be brought forth us. Now, where are the routine scenarios where we conduct a forensic assessment? First, in routine clinical cases for involuntary or supported admission, we have to conduct an evaluation for the capacity of the patient to take treatment decisions. So under the MHCA Act, the person who does not have capacity to take treatment decisions, they can be admitted under the supported admissions section 89 and 90, and for those we need to conduct a capacity assessment. Civil competence can be asked for writing will, for marriage, divorce, child custody, for writing contracts, for fitness to do duty in all those cases. Criminal cases, as already talked, pre-trial, it can be asked for regarding competence to give statement, regarding feasibility of interrogation. During the trial, they can question the fitness to stand trial, criminal responsibility for the crime committed, and post-trial, there can be fitness for execution, or there can be fitness for execution also. What are the principles of forensic psychiatry? There are certain legal presumptions when dealing with forensic psychiatry cases. First is the ignorantia juris non excusat, meaning that it is presumed that everyone knows the law. Even if you have not read, even if you are illiterate, the law presumes that you must know the law, or you know the law. Ignorance is not an excuse for committing a crime. Ignorance is not an excuse for not receiving a penalty. Principle of sanity is there, that everyone is again presumed to be sane. So until and unless proven otherwise, everyone is presumed to be of sane mind. The third principle is that principle of mental capacity. Again, everyone is presumed to have mental capacity fully. And until proven otherwise, everyone is supposed to have mental capacity. Now, the key considerations when doing a forensic psychiatry interview are that having a mental illness does not equate to unsoundness of mind. Unsoundness of mind frees the person from the charges framed against them. However, just the presence of mental illness does not equate to unsoundness of mind. Psychiatrist's role here in a forensic case is more like an investigator than a treating doctor. So our purpose is to investigate what the scenarios were, how the mind was working, what was the reasoning ability, then how did he or she end up committing a crime, or did they understand the consequences or not. Objectivity is essential. So inferences based on small parts of behavior, on pieces of information is not good in forensic psychiatry cases, as might be the case in clinical settings, that we can presume a patient to be of psychosis just on the basis of an observed hallucinatory behavior in front of us within a 2 minutes span. So we can presume it to be psychotic and we can start treatment. In forensic cases, this is not the scenario. Here, objectivity is to be there. So even if you observe a hallucinatory like behavior, it has to be noted, it has to be objectified. How long was it there? What was the exact hallucinatory behavior? Who else observed it? How frequently was this behavior? And so on. And last and most important thing is the psychiatrist's responsibility is to work for the welfare of the state. So here our work is not to protect our client or the patient or the accused, as would be the case in a normal clinical setting, so as to get the patient better, to treat the patient. Here the primary responsibility as psychiatrist is that the entire society benefits from our assessment. If the person is mentally ill, then he should get the treatment so the risk reduces. If the patient is not mentally ill and had complete capacity understanding of the crime, then he has to undergo the punishment as formed by the law. So this is the primary responsibility in forensic cases. Now talking about the forensic interview itself, what is the focus then? The focus is on, again, the legal proceedings and not on the therapeutic goals. The focus is not giving treatment, but on what the legal implications are. There is no therapist-patient relationship here. Rather, it's an evaluator-evaluee relationship, which means that unlike normal principles of confidentiality, privacy, this relationship has very limited confidentiality, as all information, reports, assessments would be submitted to court and to other relevant authorities. And often the evaluee or the accused is not participating out of his free will. Sometimes they want to hide, they want to malinger things or their behavior, so they have some sort of coercive participation in forensic interview. Despite that, in India, because of lack of resources, sometimes both the teams are same. You also have to treat the patient as well as evaluate their roles in terms of the legal issues they were facing. Besides, here documentation is not just for the purpose of diagnosis and treatment, but serves a legal use. Hence, documentation becomes very much important. What is the difference from the usual psychiatric interview? The patient has a limited choice. Patients will often be resistive and try to deceive the evaluator. The crimes that the patient might, that the accused might reveal can take an emotional toll on the evaluator, particularly when dealing with perpetrators of sexual abuse, of murder, of other criminal activities. So it can take an emotional toll, and we can develop a strong counter transference against the person. And that is why flexibility and resilience is needed. We need to change our methods frequently so that deception is identified. Timing should be flexible. Different phase of interviewing should be used and should be resilient to whatever information or whatever threats that the patient might put forth. The start of a psychiatric interview begins from accepting referrals. Referral letter, whatever comes for the assessment of the person, that should be accepted. One should always check the referral letters. It should always be in written order. No verbal order should be taken for forensic interviewing. There should be clear goals and questions as to what information do they want. Do they want about presence of mental illness? Do they want about criminal responsibility? Do they want about fitness of duty? What type of fitness do they require? Physical, mental, or do they want fitness for armed duty? So on. The goal should be very clear. If there are any vague requests, such as is the patient a such as sometimes for in a scenario when a mentally retarded juvenile conducted a crime, then it was asked that what is the IQ and if this IQ is capable of doing the crime. So this is a vague thing. So IQ cannot determine the criminal responsibility of a person. So again, such vague questions, if asked in the referral letter, they can be addressed back and specific questions can be put forth. You also have to assess whether it is feasible to conduct the assessment at this place, what time it would require, would it require other resources such as psychometric analysis, other investigations that are available or not. You should check whether you have any conflict of interest with the evaluee or not. You should mention that there were limitations of assessment, that it was a brief period or information was not available or psychological assessment is required. So that should be mentioned when accepting referral letters. The estimated amount of time that would require for the evaluation should be informed back. And eventually, this entire letter should be able to give you the right psycholegal question that you want to answer. So framing this psycholegal question would be the basic starting for a forensic interview. Now next, after you have received the letter and you have an evaluee that needs to be evaluated for the question in place, you should take consent. Although consent is ambiguous in these scenarios because often it is a forced participation from the court or the employer, still a written informed consent is to be taken. There is no skipping to a written informed consent here, and this consent should clearly mention that this is no doctor-patient relationship, such that you can break the confidentiality. You do not necessarily have to provide treatment. You have to clarify within the consent who has ordered the assessment. You have to inform the person that they have the right to refuse the assessment and what its implication can be if they refuse it. You have to inform about the confidentiality limits, that this information cannot remain confidential, and explain that certain psychological tests or other sources of information, collateral sources of information, such as other informants, persons of reference, or behavior observation reports would be collected for the purpose of interview. And finally, you have to tell that certain provisions make it mandatorily necessary to report certain crimes. For example, if a person has been brought for evaluation of suspected murder and he reveals that he have sexually assaulted the child or the juvenile also, then it is necessary to report this crime even though the judges or the lawyers might not be aware of the same. So this should also be explained within the consent before starting the interview. Now, what do we mean by collateral information? Since there can be lots of deceptions, malingering, feigning in a forensic interview, other sources of information should be actively looked for. First, the agency that has requested the assessment should be asked for information. For example, if a prisoner is brought for suspected mental health condition, then you can ask the prison medical officer or the warden for a behavioral observation report of the prisoner within the last week or month if it's available. You have to gather past psychiatric and medical records through electronic media or from the patient or relative. You have to interview other people who know the patient. To check other legal records, you can ask the police about what is the FIR, getting the charge sheet or the behavior in jail. You can use other personal documents to verify their identity, to check whether the information they are giving is correct or not, such as documents relating to their education, to their job, substance use, any past history of other offenses that they have been charged with. For civil cases where fitness for duty is to be assessed, you have to get the job description from the employer and what was the employer's report of their behavior, what was their performance like. So that can be gathered. It can be gathered from colleagues also. So those type of information becomes necessary. Now, talking about where to conduct the interview. So any setting that you conduct the interview should first and foremost ensure your and patient's safety. Sometimes when accused are brought, they need to be assessed in a private environment between the doctor and the patient, or doctor and the accused, evaluator and evaluee only. The convict or the accused person may try to escape the situation, may try to harm themselves so that they can get admitted for a longer duration in the hospital, or they might harm you. So safety should be ensured. So this interview should not be conducted in isolation, but privacy should be allowed to a certain extent, but it should not be completely isolated. For example, the police personnel accompanying the accused should be just outside the room, and the room doors can be locked with a plan for an exit strategy, or a back door facing you also should be there. So there is options for safety and escape from the setting also. Next, how to go about conducting the interview, how to style or frame your questions so that you get the best assessment. First and foremost, it has to be open-ended questions and neutral questions. Do not directly start with asking about the crime. Start with building a brief understanding of the patient's background or the accused's background. Avoid counter transference, as this is fairly common when dealing with accused and convicts. Conduct multiple interviews. Do not form opinions on the basis of single interviews. If you feel that the patient is exaggerating something or giving you false information or malingering some behavior, decept it and confront it in a firm, authoritative fashion without breaking the rapport. So this can be done by acknowledging that the patient has given two different sources of information to two different people, or within the same interview they have changed their verbatim regarding some of the instances. So that can be directly put forth to the accused. And look for non-verbal cues when talking about. This is particularly important, and this can be documented also. Now, talking about recording, you have to take detailed notes of the interview conducted. Do not forget to take it. You can record audio and video of the interview if you inform the evaluee of the recording. Now, assessment, location, and admission. Sometimes it might be required to admit the patient for the purposes of assessment. However, for stable cases or follow-up evaluations, you can conduct them on outpatient basis. But for complex cases, or where multiple sources of information, multiple specialists are required for evaluation, and longer detailed psychometric assessment or repeated assessments are required, inpatient assessment is better. Inpatient assessment is also beneficial since you get a continuous behavior monitoring, and you can also see the interaction of the person with other patients in the ward, with other staff members, how the behavior is. So you can get a direct peek into their normal routines. Multiple teams can give inputs. Multiple MSCs can be conducted in inpatient. Detailed psychological assessments can be done. Structured formats can be used, such as the nurse's observation scale for inpatient evaluation, that is the NOSI form. So these types of scales are there that can be used to evaluate the behavior throughout the day in ward. And it also enables that detailed documentation can be done. You do not have a limited time of a couple of hours to document the interview. So you can interview long and document it along the way. Certain specific things have to be taken in mind when conducting forensic interview. First is photography can be done, but with consent. If initially the patient refuses and consent cannot be taken, then later on photography can be done. For female patients, you have to screen for sexual assault in all cases, and gynecological examination and pregnancy tests have to be done. This is often missed when dealing with forensic cases, as sometimes the patient, out of her illness, may not be able to tell their LMP. They might be victims of abuse in prisons or other custodial institutions. So this gynecological examination should not be missed. In urine pregnancy test is a must for all females that are evaluated. For substance use, if substance use is suspected, urine test has to be done with consent again, and the sample has to maintain a chain of custody. It cannot be left unsupervised. The chain of custody should be maintained till it reaches the laboratory, and it should be ensured that the sample is not tampered with. Sometimes language barriers can occur. So in those situations, qualified interpreters should be used and document what language the interview was conducted in your final report. In very rare situations, sometimes foreign nationals can be brought for forensic interviewing. In those situations, first, proper documentation should be verified of their passport and visa, and copies should be attached in the document and kept at the establishment. Reporting should be done that a foreign national is residing or is admitted in the hospital. This is done to the foreigners regional registration offices, which has a form C which can be applied online on the FRRO website. So FRRO or FRO website, you can apply it online so as to inform the embassy and the government regarding presence of a foreign national in the premises. The embassy should be kept in contact, and the contact held with embassy should be in written, and again the record should be kept. For treatment, you have to follow the Indian laws, the Mental Health Care Act, for providing any treatment if they require, and the embassy should again be informed what treatment is done. Now, talking about the core of the psychiatric forensic interview, what should be assessed, how it should be assessed. First and foremost across all assessments is identifiers or socio-demographic data. The usual name, age, father's name, education, address, occupation should be done. Besides this, identity marks, photographs, and any peculiar disabilities that are present should be mentioned. Then the second heading of legal information should be mentioned. Who is the referring authority? What are the charges framed against them? What is the status of the case? Are they on bail? Are they under trial, are they convicted, what are the details of the case, the FIR reports, etc. Then we'll talk about the clinical details. So the clinical details comes secondary here. Primary comes the legal details. Clinical details about present, past, history, personality, substance use, any other mental health problems. Then we'll try to plot in a legal timeline. A legal timeline in the sense that, for example, X committed a crime on 7th June. So incidents before, incidents during the day of crime, and incidents following it. So this should be mentioned in a timeline sort of manner. This will help us understand the mental status of the person before, during, and after the incident. So 1 week's duration before and after is a good time period for which events should be recorded and mentioned. And here what the life events happened, breakup, divorce, violence with any person, any substance use. This should be mentioned 1 week prior and then 1 week after the said incidents. Besides that, how the person was arrested, where was he found, how much time did he spend in jail, and any past offenses. So that should also be plotted on a timeline. So like we put a medical, his psychiatric timeline of the psychiatric complaints, a legal timeline can be framed in such cases. Besides that, additional assessments can be done, such as psychological assessments for personality, cognitive assessments, IQ testing can be done only if it's needed. It is not compulsory. Physical examinations and other consultations can be done if there are any other medical conditions. Then comes a very important part, the ward behavior observation. This is very essential as it gives an objectivity to the said information. Till now it was mainly historical and given from the documents. Now this is the behavior that you have observed when the person was in the ward. So how the person's daily activity was he able to do their activities of daily living, maintain their hygiene, did they require any assistance, how was their social interaction with other members of staff, other patients, and what were their biological functions such as sleep, appetite, maintaining their self-care, bowel bladder habits, how were these, did they comply with the medical instructions, did they take the medicines as prescribed, if there was any abnormal or contradictory behavior, defiance, any hallucinatory behavior, abnormal anger outbursts. And as we talked about, the nosy form, nurses observation scale for inpatient evaluation, or there is also an enhanced based format for forensic interview. This you can easily find on web pages. If you just search in your browser, you can find the enhanced format for forensic interview and forensic observation. So this can be used as an objective form of tool for noting down the ward behavior. Next, the assessment should not be a single assessment, and multiple assessments should be done, but the teams should be fixed. Multiple assessments can be done, but not like if there are 15 residents in the department, every resident is doing an assessment daily. No, the team should be fixed, consisting of consultant, resident, psychologist, psychiatric nurse, or other professionals, and they should interview the person at different times, different stages of the stay. And the multiple assessment should then be verified amongst themselves for consistency, and so that the personal biases about what the accused is suffering from or is not suffering from can be reduced. Multiple assessments can again include outpatient as well as inpatient assessments. The final documentation that is to be prepared for the forensic interview should mention the date, time, and signature on all the notes, when the note was taken, and each note, each page should be signed completely. Facts should be written first. This is very important. The impression or the diagnosis that is made should not be mentioned first. It should be kept at the last. First, it should consist of all the facts. For example, if you find that person convicted suffers from schizophrenia, then write about what the history suggested that the patient would have had symptoms of schizophrenia. What information did you get? Was there past records? Did they mention that he had some symptoms of psychosis? Was he on antipsychotics? How was the ward behavior? Was there hallucinatory behavior? Was he suspicious about other people? Was he interactive? Did he maintain self-care? How was his sleep, what did he say on MSCs, did you find hallucinations or infer delusion. So based on these facts, then you infer that the person has so and so diagnosis, or their fitness, or regarding their criminal responsibility. And avoid premature or changing diagnosis. So to be sure that your diagnosis remains the same. If you are not sure, do not make a diagnosis, do not make an inference, and you can ask to review it later on. Also, the notes amongst team members, nurses, residents, or psychologists should have consistency. So they should also be reviewed before submitting it. And there should be a standard operating protocol for accessing these files, because these files can be tampered with, these notes can be tampered or destroyed. So only specified people should have a protocol for accessing these documents and notes. After the notes, observation, assessment, interviews, psychological assessments, all of the things are done, finally a medical board is to be made to formulate the final opinion on the case. So a medical board should be made jointly, as an individual opinion is not a good idea in forensic cases. Joint opinion is better. It should include the assessment team also, as well as some neutral members. So outside the team members, neutral members can be brought in from, for example, MS of the institute, CMO, any other psychiatrist outside the department, psychiatrists from different unit who have not seen the person. A shared decision making should be done, and single person based judgment should be avoided.